Andy, another day, another video.
Without a doubt, to help our clients learn more about the background screening industry. Hi, I'm Andy Scott, and this is Robert Buchholz, my partner, and we're with Scott Robertson Associates. We're the background guys. So Robert, what did you find in the New York Times?
Well, we got to do a little bit of work here, because there was an article in the Times presented on the Sunday edition, the business section on April 16th, an article by a gentleman who terms himself the workologist, a gentleman by the name of Rob Walker. Rob, it's a great article. We think it's a great article and a great topic to talk about. This is the nosy prospective employer. And let me set the scene for you. The workologist receives input or questions from individuals basically in the HR field. Situations at work, conflicts, how to resolve things. He's kind of like the Dear Abby. Now, everybody out there that remembers the Dear Abby columns that used to be in the New York Daily News, please raise your hand. Oh yeah, now we're getting a few of them out there that remember Dear Abby. Yeah, you remember Dear Abby?
Their ages are showing. Let's move on.
Let's move on that one. Okay, so anyway, this particular article, an applicant for a job writes into the workologist, and he says that he had an interview for a fantastic job, but he had some concerns that his prospective employer asked him to sign a form that says, quote, "I expressly authorize my previous employers to provide information and opinions concerning my work and work habits." And then he says, unquote, and then he says, it goes on to say that I will allow them to provide salary history and that I release them and persons connected with any request for information from all claims, liabilities, and damages for whatever reason arising out of my furnishing any information that may be sought in arriving at an employment decision, unquote. So I thought, when I read that, I said, wow. I mean, that's a pretty significant authorization form. Now, we do authorization forms. We provide them samples, suggested copies for our clients, and obviously we always tell them, run that past corporate counsel.
Sure, sure. What the issue is here with that particular quote that Robert had cited, of which the consumer was complaining about, the consumer was actually complaining about, does the employer have a right to inquire about my salary from my previous employer? But what Robert and I found to be more distressing, in fact, the most distressing aspect of this, was the waiver language that was used in that authorization/disclosure form. Now, remember, we're not attorneys, we don't give legal advice. However, our professional group that we belong to the National Association of Professional Background Screeners, has emphasized through a number of legal counsels making presentations to the group that waiver of liability attached to as part of the content of the disclosure/authorization form is strictly forbidden. That no employer should put any type of waiver of liability in the language of the disclosure/authorization form. If you do, you're setting yourself up to be potentially sued.
Right, and it's a big deal. It's a big deal because you're not in compliance with the Federal Fair Credit Reporting Act, which governs, to a large part, background screening for employment. And that particular legislation, this federal legislation, specifically states that the authorization disclosure form must be solely that you can't add additional language to that. And when this particular employer, based on the report in the press, when this particular employer added a waiver of liability to the form, including that on the form, he then violated the Fair Credit Reporting Act. Why is it a big deal? Let me tell you. One, it's already been withheld in federal court, and there's several court decisions, we can quote two, that specifically say including that type of language or any language other than the authorization form language itself is in violation of Fair Credit Reporting Act. And number two, it's not just that this particular applicant, this consumer, may have been disadvantaged as a result of that because he wouldn't sign the form, therefore he didn't get the job. the question really is that tort attorneys will come back and not just sue on behalf of one consumer. They will come to an employer and they will sue on behalf of a class of applicants. And if you have a class of applicants and this particular form has been in service at your company for 3, 4, 5 years, every applicant that may have been disadvantaged or by that language can be included in the class at the cost of at least $1,000 per.
Correct. Plus, if they can prove damages as well as a result of not getting the job because the waiver was not signed. Now, with that being said, there's the disclosure form and then there's the authorization form. When you file for employment, an application for employment, the authorization form has to be separate and distinct from the application. That authorization form means you're giving permission for the company to use a third party to do a background screening. Now, there's another part of the authorization form which they call the disclosure form. That disclosure form tells the consumer what type of search is going to be done, where they're going to search for it, so on and so forth. But the bottom line is both of those forms can be combined into one, but the consumer or the applicant must sign it. Any language that has a waiver of liability within those forms potentially sets up the employer for litigation that is just so easily avoided by removing any type of liability waiver language from the authorization form, disclosure form.
That's true, and so the effort here is really, and what Andy and I constantly try and do is to inform our clients and everyone, individuals, whether really you're in the employment arena or if you're in a tenant arena, the idiosyncrasies, if you will, of the law. We make recommendations, suggestions, and we always ask you to go to corporate counsel, your corporate counsel, for the ultimate decision. We are not attorneys, as Andy has said. 2 court cases that may be of interest, and that's Syed, that's S-Y-E-D, versus M-I LLC, and Reardon versus Closet Made. Closet Made, everybody knows that manufacturer. And these are just 2 federal court cases that rule that the inclusion of liability language or any other language in the disclosure authorization form is improper, based solely on the requirements of the Federal Fair Credit Reporting Act. You know, Andy, we're here at Scott Roberts. We're here every day. We would love to have some questions, some feedback from the viewers as to this particular video, or if you had a question about a background check, or how to do a background check, or what's a good way to do background screening, what are the requirements, any type of questions that deal with that particular subject, we're available.
Please, and even if you don't have a question related to this particular topic that we discussed today, we'll be more than glad to answer any of your questions that we can answer within reason or direct you to the person that can answer those questions. We'd love to have your business. We'd love to hear from you. Remember, Scott Roberts and Associates, we're the background guys. You could reach us at info@scottrobertsassociates.com.
Before we close, I just want to say, generally speaking, when you're dealing with a vendor like a background screening company, we know and it's the habit here as well that clients get used to you, and clients are reluctant to make a change, even when that background screening company, that particular vendor, is not doing what you feel is the best. You can always come to us, ask us for a competitive quote free of charge, never any obligation in that regard, and we're happy to help you in any way that we can. Don't be reluctant to call us. You don't owe us anything, there's no obligation.
Have a great day. We'll see you at the next video.
Thank you.